Fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something.
Mr. Bragdon.
David
Bragdon.
Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
It's going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's turn your
This
mic
is
on for me,
Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay.
Welcome to Liberty Trigger. Patriots, buckle up, because what I just watched in the Senate hearing shows exactly how America is being tied in knots by lawyers, bureaucrats, and activist judges. It's not about freedom anymore. It's about control, and we're going to break it all down right now. They asked a simple question. Can a small business owner fire someone for showing up in a burqa? And the answer, thanks to Washington lawyers, is basically, and oh, let me be clear, religious freedom is sacred. But here's the problem. What about the business owner's freedom? The guy who built that company, who pays the taxes, who risks it all, he has zero say? And when the nominee was asked if customer preference matters, he said, no, that's not justification.
Let me go back to Mr. Rousseau. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction, and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the
that
same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits.
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors.
Folks, if customers walk away, that business dies. That's not theory. That's reality. But reality doesn't matter in Washington, only politics. They finally admit, if it's unsafe, maybe the owner has a case. Maybe. Think about that. We've reached a point where a man who owns the machines, pays the workers, and knows his business best has to beg the courts for permission to apply common sense. If you can't say no, this is dangerous without checking 50 years of case law. Your freedom as a business owner is already gone. Then we get to supplemental jurisdiction. One nominee couldn't even explain it. Folks, lifetime federal judgeships, and they can't remember basic principles. But hey, as long as they check the right political boxes, they're on the fast track. Another question. How do you amend the Constitution? The answer is Article 5. 2/3 of Congress or the states. Straightforward. But here's the danger. Too many judges today think they can interpret the Constitution however they want. That's not how America works. Our founders didn't make it easy to change for a reason. They want to stop power-hungry politicians from rewriting freedom every election cycle. They ask about injunctions. Temporary versus permanent. And what do we hear? A bunch of legal jargon about equities and merits. But here's the truth. Injunctions are how activist judges froze churches during COVID while keeping strip clubs open. Same law, different results. Because it's not about law, it's about politics. And then class actions. Lawyers call it Rule 23. I call it legalized extortion. A few lawyers round up a class, bleed businesses dry, and walk away rich. And the nominees, they just nod along like it's normal. But patriots, it's not normal. It's destroying small businesses across this country. So what we see here, nominees who don't run businesses, don't sign paychecks, don't live with consequences, but want the power to dictate how you live and work. We need judges who honor the Constitution, respect business owners, and defend freedom, not lawyers who hide behind technicalities while America bleeds. Because this country wasn't built by bureaucrats in D.C. It was built by farmers, truckers, welders, small business owners, the backbone of America. And it's time we start protecting them again. If you believe in freedom, in common sense, in the Constitution, hit like, hit subscribe, and share this video. The fight for America isn't in the courts. It's in the hearts of patriots like you. God bless you, and God bless the United States of America.